A couple of months back, India decided to ban a lot of Chinese apps. That gave room to a lot of conversation and reactions. One of them was calling it a very smart move, the others called it not so smart. There was this entire section of society that started throwing their Chinese appliances out of their windows after paying for it. But there's this huge section of conversation that was somehow missed out upon the constitutionality of this question about banning the Chinese apps. Ladies and gentlemen, welcome to the One Take Show, a podcast where we celebrate incredible conversations with some fantastic people. In this episode, I am honored to host Mr. Vivek Sood. Sir is a senior advocate at High Court of Delhi. Sir has been a pioneer in cyber law. Sir has over 3 decades of experience in criminal law, constitutional law, in cyber disputes. He's also authored some of the most fantastic books in cyber law, if I may just name them: The Fundamental Right to Internet, Cyber Law Simplified, and Cybercrimes, Electronic Evidence and Investigation. In this episode, Sir is going to talk about his experience with litigation, his experience with law. He will also answer all the questions around the topic constitutionality with respect to banning the Chinese apps. If you like this episode, you find it useful, make sure you subscribe to the channel. Drop me a comment if you think anything needs to improve or anything else needs to be done with this podcast. You can reach out to me anytime you want. And ladies and gentlemen, without further ado, let's jump right in. Hello, sir. Welcome to the One Take Show. What a pleasure it is for any student like me to have this opportunity to learn from your vast experience, to have this opportunity to talk to you and to host you on this platform. Thank you so much for taking time off your really busy schedule and sitting down with me for this amazing conversation that we're going to have.
My pleasure.
So, before we get into the outstanding topic that we are going to cover, something so contemporary, something that is affecting the nation at large, I would, as a student and as a legal aspirant, would love to know about your journey. I think your experience has inspired law students, legal aspirants, the legal professionals across the country, and to learn from your experience would be an opportunity that I should not miss out upon. So could you please tell me a little bit about what inspired you to do law, what inspired you to move with law, and what were your standout experiences?
So I was born to be a lawyer. First of all, I'm a third generation lawyer in the family. My grandfather used to be a leading lawyer in Lahore and after partition in Punjab. And my father used to be a leading income tax lawyer in Punjab.
Mm-hmm.
So the profession is in my DNA. It is in my blood. I grew up, seeing law.
Mm-hmm.
So law was the only choice. Now I went to Mayo College, Ajmer.
Mm-hmm.
And I remember, as a child, when the teacher or somebody would ask, what do you want to become in life? So you had students saying pilot and Air Force and Army officer and businessman and etc. etc. And here I said, I want to be a lawyer. So I was, the odd one out in my Mayo days. But law came naturally to me. It was there on the dining table every day with my grandfather and my father. And then therefore, it had to be law as a career.
Right.
And I went to the law faculty in Delhi. I finished my law in 1992. I worked with, the stalwarts of the bar. And then I branched off on my own after, say, about 5 years of training with Amarchand Mangaldas and ML Verma, senior advocate and a retired Delhi High Court judge. And then it was, a tough journey initially. And I worked my way. I had the passion, I had the vision, I had the discipline. And very early in my career, I, started writing.
Okay.
I started writing articles, initiated with writing for Tribune, Indian Express, the Economic Times, and then after having written about 200 articles and papers, I realized that a newspaper article has only one day's life. The newspaper comes in the morning and
Right.
it's in the bin by the evening.
Mhm.
So then I thought of doing something which was more permanent in nature. And then I conceived my book, my first book at the age of 30, which is titled Cyber Law Simplified. And Tata Mcgraw published it. The IT Act came into force in the year 2000, and my book was released in 2001. So it was a pioneering work. It wasn't a typical law commentary. It was an issue-based book.
Absolutely.
And I feel proud in saying that it's still selling today. And I have not revised it. So you can imagine, it has made an impact by itself.
Absolutely.
Then I kept on writing. I wrote my second book on cybercrime, electronic evidence and investigation. And then came my, my best book till date, that titled The Fundamental Right to Internet.
Right.
So I coined the expression, the fundamental right to internet in India in the year 2011. Now the Supreme Court used this expression in 2019 while deciding the Kashmir shutdown matter. So, that's, and then alongside my writing was the professional journey. Initially, I did everything under the sun, whatever came my way.
Right.
From, civil matters, criminal matters, MRTP, and, all kinds of commercial matters, etc. And then, with time, I drifted on the criminal side.
Okay.
It is, I think the litigant found me better as a criminal side lawyer.
Okay.
Than, as a commercial lawyer or something. And so I drifted more on the criminal side, which meant that I was doing 90% criminal matters and 10% was the rest. And I dabbled a lot in the trial courts. So I've done maybe about 500 trials. I may have cross-examined about over 1,000 witnesses. And of course, with that came the appellate work. In the High Court, I did a lot of murder appeals, a lot of economic offences, a lot of writs, revisions. So I was very busy, all through. And with the grace of Almighty, I got designated in 2015 as a Senior Counsel from the Delhi High Court. And then, my practice changed. It was the second innings where, the junior lawyers and the law firms, they come and they brief you and you add value to the brief and you argue the matter in the court. So that was the second innings, and which I am enjoying, and I'm very passionate about my work, and I believe in growing every day as a lawyer. And it's a fantastic profession to get into, and so that's in a nutshell been my professional journey.
Absolutely inspiring. I think there's so much to unpack here. As an aspirant, it would be very criminal on my part if I don't ask you follow-up questions. But I won't dig much deeper. But there are certain points that I would love to follow up on. You mentioned that you've used passion and discipline to stick with your profession, especially when it comes to litigation. We see a lot of legal aspirants either having a burnout or after certain years they cannot last, which is a huge problem when it comes to them making their niche in litigation. What suggestion would you have for such litigants when it comes to discipline, and how can we inculcate that kind of passion when it comes to area which is so difficult like litigation is?
Okay. So if I can, state my viewpoint on this burnout, etc., and litigation lawyers don't last in the courts beyond a few months or a few years. I believe that you must burn all your boats. You must burn all the other boats that you have.
Okay.
You can't be a litigation lawyer and thinking about working with a law firm and earning a huge pay packet, or looking at your colleagues and contemporaries who did MBA, chartered accountancy, and you see them grow. Or you see your colleague who joins a law firm and he's he or she is growing and becoming an associate and a partner, and 5 figures, 6 figures, 7 figures.
Absolutely.
You can't be looking at that while going to the court. So you must burn all your boats.
Perfect.
Which means you have to take the plunge in the ocean.
Right.
And and the ocean will throw you up. You will not drown. I can guarantee. I can give if you want, I can give a bank guarantee to any youngster. Nobody drowns.
Right.
So and every matter is important, whether it's a highly paid matter or it's free, it's pro bono, whether the client is very rich or poor or whatever. Every matter has meat in it. So whenever there's a brief on the table, there's an inherent desire for me to open it and unravel the mystery and find out and get the answer.
Right.
So, every lawyer should, every litigation lawyer who's aspiring to be a counsel should take up all matters in any court. It's as enjoyable to appear in the lower court before a magistrate as it is before the Chief Justice of India. A court is a court is a court. And, I say, if I am engaged, and if I am now paid, I will appear before the lamppost also, and or before the tree, the banyan tree, and I will address arguments. So it doesn't matter which court you are appearing, it's Saket Court or Tisazari or Hapur or Ghaziabad or Supreme Court or High Court. So it's the passion is the driving force. And if you are passionate about litigation, you will swim. Of course, it takes a long time to emerge. And, then comes destiny also. Destiny plays a big role. You may do good work and destiny may not reward you to that extent or may reward you a little later in life. But I have never looked at the rewards that the profession gives you. It is the passion. That it's an intoxicant, I would say. When I appear in the court, it's an intoxicating experience. So if you are excited about the morning, I'm sure one can survive and there's no question of a burnout. Your contemporaries in law firms and the corporate world will burn out. And at 50, 55, you will be young and agile and you will be excited, while they'll be bored and all that complacency, etc. will set into their careers. Because as a lawyer, every case is different. Every time you appear in the court is a challenge. So that makes life very exciting. So there's no question of burnout of a litigation lawyer.
Perfect.
Of course, if you're looking at monetary rewards only, then perhaps the answer is a law firm or a corporate career. I don't disrespect those careers. They're very stable and they are very consistent. They give you that consistency in life. As a litigation lawyer, there's a lot of struggle. There's a lot of difficult times that you face. No money, no work. No money, work. Work, money. Of course, now it's more money and less work. But that's the journey of life.
Absolutely. I think that is the return that you get when you invest for so many years, and that is the pedestal that you reach. And that is, I believe, the target for any legal aspirant who's trying to enter into litigation. So my next question to you is, again, a follow-up, but a rather two-faced question. Firstly is, if you could go back in time and could advise yourself as to what all are the things, skills, or let's say these are the tips that you could have followed to make your beginning easy or your entry into the industry easy, what would those tips be? Or maybe the juniors who join you, what advice would you have for your juniors as to how they can acquire certain skills to become suitable juniors or potential successful candidates?
See, I don't look back. So I don't brood. I'm not a brooder. I'm not an auditor. I don't audit my life in the past. I live by the day. And for me, every day is a celebration.
Right.
But for youngsters, if I can advise them, I would say that they must cultivate the art of finding the law.
Okay.
Finding the law is very important because you are confronted with big files, so many papers. So to find the issue, from that bundle of 100-page brief or whatever, to find the issue first of all, and then to find the law. I'll just illustrate this. For example, I am now going to do a very important murder appeal. It's an SLP, which is
Okay.
coming up in the Supreme Court later this month. It's a case of kidnapping and murder for ransom, and we have two courts against us, and the brief runs into 4 or 5 volumes. But of course, now with my experience, I've been able to find the issues. But a young lawyer should be able to encapsulate or condense the matter, maybe to 1 page. After all, in this brief also, or any criminal brief, you will have 6 or 7 or 8 or 10 circumstances that constitute the entire case. Rest is all peripheral, all introductory facts and all that. So first of all, young lawyer should cultivate the ability of finding the issues. In civil matters, it's called an issue. In criminal matters, it's called a fact in issue under the Indian Evidence Act. What is a fact in issue? What are the facts in issue? So, find those issues, encapsulate the matter, condense the matter, and, find the law. I think that's my advice to young lawyers, and that's the assistance a senior counsel or your senior will want. How best you can summarize the whole matter.
Right. Perfect. I think this is the kind of advice which will help a lot of law students, especially the legal aspirants, who now understand what to look forward to as in their performance perspective and how to contribute into their workplace better with this kind of advice. So my last question in this segment with you is that obviously this is something so very unique to you. You've authored some of the most remarkable books when it comes to digital sphere and cyber sphere. What was your experience with authorship, and how did you find this entire engagement when it comes to its contributing value in your professional life?
See, first of all, to write a book is not very easy. It is almost like conceiving a child and delivering the child. It's it's a challenge by itself, but then passion is the driving force. And when you get into writing a book or authoring an article, so it involves research first of all. So you cultivate the habit of researching into the topic or the subject you pick up. Then comes the articulation. Once you have done the research, then every book or every article is an expression of that research.
Right.
So the expression is, then you cultivate the art of articulation. And the third element is the element of creativity, where you add value to what you have researched and what you have articulated, and what is your value addition to the subject. I have not written these commentaries. Commentaries in my view are, they're extremely boring. They're like the sleeping pill. If I was given a commentary to read, I would sleep in no time. So they have their own value. When people who are handling briefs and you want law on a particular provision, so then you refer to a commentary. They are reference books. I have been writing issue-based books. So authorship is very engaging. And currently I am writing on commercial justice. It is on arbitration and the insolvency and bankruptcy code.
Wow.
So I think it should be released next year. I've used this sabbatical. Of course, I do video hearings in the morning. I do about 3 to 5 in a week. And the post-lunch session, I devote my time, reading and writing. So I'm not missing anything at all. My day
Right.
is as short as it was earlier. So I believe in a 16 to 18 hours a day,
Okay.
and it just rolls by. I don't get to know also.
Perfect.
So I would advise youngsters to write more, to
Mm-hmm.
write articles, to write papers, to have them published. There are so many platforms now, offline and online. And,
Mm-hmm.
and then if you have a bigger project in your heart, then you can conceive a book and deliver the child.
Absolutely. I think what is more important for law students, especially like me, who are interested in technology and absolutely tying interest in arbitration and insolvency and the interplay, I think I am eagerly waiting for the book. And I think I have been very oblivious to the fact that there are such amazing products available for us to learn from. So I am hopping onto that immediately. In fact, I will be linking those books down so that every listener of mine is aware of the fact that there is a huge knowledge, a sea of knowledge that we can actually learn from that has influenced not just judgments but legislations in our country in a way or the other. Thank you so much for that segment of this conversation, sir. Now we move to a rather very interesting concept, which is very new, so contemporary, and is so valid to our Indian political scenario, Indian legal scenario as well. India recently has banned Chinese apps. There are a lot of apps like TikTok, WeChat that have been banned. One issue that is being talked about is constitutionality. And who better to explain this but you, sir? I think to learn from you is an honor. So could you please a little bit conceptualize for us what is it that you propose here as an idea, and what is the understanding that we should have from this issue?
See, I would like this session to be more interactive, in the sense that you could pitch questions on me, and I will endeavor to explain and answer them. But just to, just as a prologue, if I can say so, 59 sites, Chinese sites, were banned on around 30th of June 2020 by the government of India, under section 69 capital A of the Information Technology Act of 2000.
Right, sir.
On the ground that, these websites or these platforms allegedly, they were affecting, or they would affect, or they have the potential of affecting the sovereignty and integrity of India, and the security of the state and
Right.
friendly relations with the state, etc. And now, see, the constitutionality is one subject which has not been gone into, because I think the issue
Correct.
has been very emotively dealt with by the media. That the China, and maybe the virus came from China and they are the ones responsible for the pandemic, and what was happening at the borders, the standoff around the 15th or 16th of June. So with that baggage, this issue has somewhere got lost in that baggage, in that maze. And so therefore I feel the issue is contemporary, it is important, it is worth a debate. And there hasn't been a debate on this, on the banning of these sites. Had these sites been Indian sites, there would have been a debate, and maybe you would have had a flood of writ petitions being filed across the country. But I find that there has not been a constitutional debate on this issue. So therefore, with this prologue, we can start the dialogue. Let it be interactive. Let the questions come from you, and I will endeavor to give my perspective on the subject.
Absolutely. I think so. This is a very interesting topic, and this is absolutely true. The fact that there has been no such discussion around the constitutionality of the matter, because there's one big concern, and I think this is my first follow-up question to you, is that Internet of Things, the access to Internet is considered to be a fundamental right for Indian citizens. And this is an issue which has been somehow touched by certain judgments and has been raised by multiple websites, multiple journalists, that how can a state deny the access of certain internet websites to certain people who have subjectively benefited from them. For example, certain enterprises have really benefited from TikTok or WeChat, or Tibetan people have really benefited from WeChat as they stay in touch with their roots in Tibet. So all of this, when it comes to access to internet, how is that issue something that you would look upon, and what is your opinion on the same?
So, you first of all, may I just say that access to the internet is yet to be accepted as a fundamental right under our
Right.
constitution.
Right, sir.
The fundamental right to internet is an expression which I coined in my book in 2011, and the Supreme Court has used it in one of the judgments in 2019. But the concept is yet to be recognized either by the judiciary or by the legislature. So it's a futuristic concept which will find its time. Its time will come. But as of now, access to the internet, in my view, can be read as a derivative right in Article 21.
Okay.
So, Article 21, the right to life and liberty. You know, we all know that it has been expanded over the last several decades, and myriad rights have been included within the ambit of Article 21, right from environment to so many issues, to building a road in a village, or medical facilities, etc., etc. We are talking of accessing the internet. If the state tomorrow, if the government tomorrow was to shut down my internet, so we are talking of access to the internet. Access to internet will be read in Article 21 in my view.
Okay.
Once I have logged on to the internet is a source of abundant information. So here comes Article 19(1)(a), the freedom of speech and expression. It's a platform where I exercise my freedom of speech and expression, where I even learning from the internet. Even learning is a part of freedom of speech and expression. So Article 19(1)(a) comes into play. Then the internet gives me the opportunity to bond with others. So it enables fraternity.
Correct.
So in my view, different aspects of the internet touch different fundamental rights guaranteed in Part 3 of the Constitution of India. Now, in my book, The Fundamental Right to Internet, I have spoken about the internet creating an egalitarian society. Internet is a great leveler. It's a great equalizer. Everybody is equal. A rickshawala who comes on the internet and Mr. Tata who comes on the internet, whoever comes on the internet, it's an equal platform for all. There's no distinction, there's no discrimination. So I have said that the internet also facilitates an egalitarian society. It facilitates equality, which is one of the enshrined, pillars of the Constitution.
Absolutely.
In the preamble and Article 14. So internet has different dimensions to it, and the internet facilitates several fundamental rights in different ways.
Okay, perfect. And to that point, sir, when it comes to the access of internet, you've mentioned that the fundamental right is yet to be accepted when it comes to access to internet. But what authority do we attach to a sovereign state like the Government of India when it comes to banning certain apps or websites on preconceived allegations that such apps would be dangerous for the sovereignty of the country, or they might be data theft or any other such danger? Does the sovereign state of our nation derive such an authority to take preemptive measures without having full proof of any such controversies with respect to these apps? Or should we be careful about the same, like countries like China keep banning websites like Facebook, Google, without any particular clarifications about the same?
First of all, we should not equate our state and society with that of China.
Absolutely.
China has a different set of laws. They have their own constitution. They have a one-party government. So it's not a democracy. We are a democracy. So,
Absolutely.
we follow the constitution in letter and spirit. So, in my opinion, the government of India, the state, must follow constitutional principles.
Absolutely.
Constitutional morality must be there in the, government decisions, especially when it comes to, deciding whether to ban these websites or not. Now, once
Okay.
we apply constitutional principles,
Mm-hmm.
to this action by the government of India, I find that the grounds for banning are really not made out. Ex specie, they are not made out. Now, for
Okay.
example, TikTok. TikTok is a video clip, where you make a short video clip of 33 to 60 seconds to make
Mm-hmm.
these short humorous video clips, and you circulate them, you express them, you enjoy them, you interact with them, you talk about them. Now, how does it affect, the sovereignty of the country, the
Right.
integrity of the country, or the security of the state? Let's assume, for the sake of argument, that the data, the people who are using TikTok,
Mm-hmm.
the TikTok platform, the user data may be going to China, or they might be making some list out of it,
Mm-hmm.
and with that list they will promote some new website. It will be, of course, it will be used for some business purpose.
Right.
I don't see anything more into it.
Mm-hmm.
So, from a constitutional perspective, I feel that the grounds are missing.
Okay.
But there are two sides of the coin.
True.
If you look at the political element of this,
Mm-hmm.
then we will have a different debate.
Absolutely.
I'm not saying that there's no political element to it, or
Mm-hmm.
the political element is redundant, or
Mm-hmm.
it has no meaning.
Mm-hmm.
See, every act that we do,
Mm-hmm.
in our country, every human act is not backed by the Constitution of India. So,
Mm-hmm.
Constitution is not governing every human act that is being done.
Right.
So, so the political perspective
Mm-hmm.
has its own importance. Now, I'll come to that when you ask, the relevant question.
Mm-hmm.
I will deal with that aspect also. But from a constitutional perspective,
Mm-hmm.
TikTok is an expression of my view by making a clip. So it
Absolutely.
squarely falls within the ambit of Article 19(1)(a), the freedom of speech and expression.
Mm-hmm.
Now, the state under Article 19(2)
Mm-hmm.
can impose reasonable restrictions. Now, the restrictions have to be reasonable. Now, restriction includes a prohibition. You can prohibit.
Mm-hmm.
But there has to be a ground for prohibition. There has to be an imminent danger, a pressing need that you want to restrict this freedom of speech and expression. That's how freedom of speech and expression has developed over the last several decades by the Supreme.
Mm-hmm. And to that extent, sir, I think what you mentioned, that the constitutionality is something that does not govern every human part of every human behavior of the citizens, and perhaps the political sphere itself is given this sort of autonomy to function and to govern and to kind of create a space of its own. At this point of here, we say there is a line of argumentation from the other side which support this Chinese app ban. They argue that just the fact that there is a threat to let's say data breaches, or there is a threat to sovereignty, should be enough for the governments to overlook the constitutional explanations that need to be provided, just like United States, for example, is also going to do in a couple of weeks, if I'm not wrong. Should that be an argument that we should accept, or should I reconsider this argument?
So, from the political perspective, my view is that if you equate the situation that happened on the border, or Chinese government banning Indian websites, that's also happened. So if you look at the whole situation as a war-like situation,
Okay.
if you look at it from a war-like situation, see, warfare in this day and age is not what we see in Mahabharata and all that, where the armies went on a particular football field and then
Right.
they
Right.
engaged in a direct warfare, and
Right.
and the king was captured or he was beheaded, and
Mhm.
the kingdom was taken over. That's not the warfare that is existing today.
Mhm.
It's a very subtle warfare. Cyber warfare is also happening. Something is happening at some border. Some skirmishes are happening here and there. Diplomatic warfare is happening. War of policies is happening. Trade
Mhm.
war is happening. So if you look at it as a warlike situation,
Mhm.
then the decision of the government of India gets legitimized. That people expect
Mhm.
a reaction, a response to what is happening. What is
Mhm.
happening in China, vis-a-vis the Indian websites. If they
Mhm.
can do this in retaliation, we must also react. So if you
True.
look at it from a political, social perspective, it
Mhm.
may be justified. But from a constitutional perspective, as lawyers, we fall back on law for on every issue. So and we forget the political and the social fallout, or the
Mhm.
social relevance or the political relevance. But
Mhm.
I gave a thought, I pondered over this aspect. So there is a dichotomy, there is a distinction.
Okay.
From a constitutional perspective, I find that the grounds do not meet the standards of
Right.
reasonable restrictions, or the ground of sovereignty and integrity of India being affected, or the security of the state being affected. I would
Mhm.
rather go in favor of the freedom of speech and expression,
Okay.
rather than on the restriction.
Mhm.
I am a firm believer that unless exceptional grounds are made out, and exceptional grounds which are proven, which are made out almost to the level of conclusivity, freedom
Mhm.
of speech and expression should not be really tampered with or touched, or
Absolutely.
be affected. I am a firm believer of free speech.
Mhm.
I follow that at my home as well.
Right.
My children and all, they have the freedom of speech, of telling me I'm wrong. So
Mhm.
I'm a firm believer of free speech and not reasonable restrictions or restrictions. I don't believe in too many restrictions. In that way, I'm more of the US Constitution, which
Mhm.
does not have Article 19.2. Of course, by judicial interpretation, they have read that freedom of speech cannot be absolute.
Mhm.
But the grounds of restriction are very narrow in the US.
Correct.
I'm a firm believer, I follow that ideology. So,
Correct.
from a political perspective, the government of India, may have done the right thing. After all, they have to look at the people. You have to be a bit, you have to be populist. You
Mhm.
have to look at the emotional aspect, what
Okay.
people want,
Mhm.
etc. So we have
Right.
to, it's the position you take, it's the issue that you frame
Mhm. Mhm.
that is the most relevant.
Perfect.
As a political issue, it
Mhm.
may be the correct thing to do, but from a
Mhm.
constitutional point of view, in my view, it is unconstitutional, and these grounds are not made out for banning these 59 Chinese sites.
Perfect. 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 I think I just have a last question or perhaps a pointer so that we can have a conceptual sort of an understanding of this entire issue. You have very wonderfully explained to us how the constitutional parameters are not something that have been established in a way to explain these actions. Sort of comes off like a knee-jerk action from on the part of, or it's a very political explanation that is being provided here. One point here is that since our government follows the principles of good governance, where it is the least government and most governance, and at that point, bills like personal data protection bill is being introduced and banning of these apps. What is your in general opinion, as sort of a closing remark on this entire issue? What is your in general opinion as to what has happened, what could have happened, and what should have happened? And in totality, what is your entire take on this issue?
in my view, breaches will always happen.
Okay.
Crime has existed since time immemorial.
Mm-hmm.
It will always exist, It will
Right.
never go away.
Mm-hmm.
So the moment you have a technology like the internet, you have a platform, a global platform like the internet,
Mm-hmm.
data privacy breaches will happen.
Right.
Cyber terrorism will happen, cyber warfare will happen, cyber crimes will happen.
Mm-hmm.
All these are part and parcel of the internet.
Mm-hmm.
Now, therefore, yes, now the state must make an endeavor to mitigate it, to reduce it to the maximum, to keep
Right.
it to the minimum.
Right.
Or if it happens, there should be deterrent action
Okay.
against the culprits. But
Mm-hmm.
to say that it should not happen at all, then it's better not to have the internet.
Agreed.
When you have the internet, there shall be crime, there shall be viruses, there shall be breaches, all this.
Mm-hmm.
So you design your laws, you make your laws, you enforce the laws also in letter and spirit. Of course, there are so many challenges of finding the cyber criminal, finding the evidence. It's a cross-border crime. Cyber crimes cross geographical borders with luxurious ease, and the criminal need not visit the bank physically to hack into the account and misappropriate the money. Those
Absolutely.
challenges are there.
True.
But every society, every country, including India, has made its laws. Laws will continue to be made. They should be implemented in letter and spirit. But this breach will always exist. Now, if we get hypersensitive about these breaches, then you are trespassing into the rights of the citizen. You're trespassing into the rights of the citizens. You are trespassing into freedom of speech and expression. Then
Right.
you are encouraging a fortress society, a closed society, a very regulated society. Then you will say Inspector Raj has come, and the government has become very, very conservative, etc., etc.
Okay.
So this is my thought on this. So let us have all these laws. Let's have a gamut of laws. Laws will keep being legislated, and they should be implemented also. But crimes will exist.
Absolutely.
Keep them at a minimum level is what the government of India should strive for. Rather than playing the big brother and playing the big regulator who wants to regulate and control everything so that there's no crime. So then you have a society like like in the Middle East,
Right.
where extreme punishments are prescribed, and and then it's a zero crime society. But in a democracy like ours, we cannot really have a zero crime society.
Right. So I think this is a kind of in-depth understanding of the jurisprudence, which really gives us a perspective as to what is the balance that we as a nation are actually striving for, and what is it that we're looking forward to. This is the kind of conversation that opens the minds and opens the perspectives for anyone who listens to this kind of conversation. Personally, I have really started thinking about this entire issue from a very different perspective. I don't think I have really questioned this move of government before, and in fact, even now that I look at it, I think I will start looking into the constitutional perspectives, and so will all the listeners who will listen to this conversation. Thank you so much, sir, for this amazing segment. Do you have any closing remarks for our listeners for this podcast?
It was a pleasure, being on this platform, and the issue was very interesting, fascinating, something new, and I always believe in creative issues being taken up, rather than the run-of-the-mill kind of arguments. So it was wonderful to be interacting with you on this platform, and I hope the audience will also like the way we have dealt with these important issues, and these issues will keep coming up.
Absolutely.
Thank you.
Right. So as you've mentioned that there is a lack of discourse when it comes to issues such as constitutionality with things that are happening right now. For example, the ban of these apps. What this conversation will do, for the least, is start that discourse, will start that conversation. People will start actually engaging into this kind of an intellectual conversation and will bring about solutions and perhaps come up with better arguments, all because the inspiration that we've received from your knowledge, from your experience, and obviously from the kind of guidance that we've needed so far so as to open our minds to this possibility. Thank you so much for this amazing opportunity.